law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bw has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bw is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello. You're welcome to today's program, Hanging Out with Bw Solicitors. I'd like to say good morning, good afternoon, good evening to everyone watching all over the world. I'm so privileged to come your way today, this beautiful Saturday in UK, London. As usual, this is an immigration law program. And if you want to contribute to this program, you can do so on our Facebook, YouTube, and all social media handles at BWF Solicitors and Vicky Newton's page. You can also live on YouTube. If you'd like to contribute to this program or even ask your questions, you can do so on our social media handles, especially Facebook, where we are transmitting live. Would be my solicitor, Lawyer Eunice Achampong, will answer your questions. If you prefer to call me live in the studio, you can do so on 0744 8619 711. Let me introduce Lawyer Eunice quickly, then I will discuss what topic we are doing today. Lawyer Eunice, you are welcome to Hanging Out with BWF Solicitors.
Thank you. How are you?
I'm good. And you?
My throat is a bit itchy, but I hope it will be okay throughout the program.
I hope
but I'm glad the sun is out. At least we don't have any bad weather today, so I'm glad.
I think that shows in our chosen attire for today. Would have been in a jumper or something with a scarf, isn't it?
Yes. So it's good that at least we have the sun out. It's a bit warmer, so we can wear something which is a bit more summery.
Exactly. Exactly. Yes. Today's discussion is that receiving some type of disability benefit exempt an applicant from the 18,600 financial requirement. Before we delve into it, I know you have been very busy this week, and definitely you might have some,
Updates
news going
coming. Yes.
around. Yes. So
Yes.
if you could please um, give us a brief what's going on for people to know, that would be
Yes.
great.
Okay. So I'm sure we all watch the news and we all can see what's going on in Russia.
Yeah.
And I think that we wouldn't expect to see something like this in our day and age when we say we live in a democracy. It's
Yeah.
government for the people and by the people. But unfortunately, we have people who like to have power in their own hands and do what they will with that power. And so it's a shame that we have Russia invading Ukraine for no reason at all, and obviously trying to take over that country. As part of the UK government's, should I say, efforts to try and make sure that those that escape will have a place to call home, they said if you have British citizen family members and you would like to apply to come to the UK, you need to phone their hotline. And once you have phoned their hotline, they will send you an application, which they decide within 24 hours. So whether you have a parent or a spouse or a child here in the UK who is British and you're from the Ukraine, they will give you access to the application where you can apply to come to the UK, and that decision will be made within 24 hours. And also for those that are Ukrainian who don't have any family members that are British, the British government has also said that they would obviously renew their asylum policy in regards to Ukraine because of what is going on at the current moment. And so they will allow Ukrainians to apply for asylum if they come to the UK as their first port. Or place where they would like to seek refuge from the war that is going on in Ukraine right now. And I say my heart goes out to the people of Ukraine, and we're hoping and praying that they don't kill as many civilians as they have planned, and that many of them will escape what is currently going on right now. Um, yes, so in terms of um, our applications as well, I know a lot of us who made our Zambrano applications, and those that, of course, have the 2.5 years leave to remain and are looking to see whether or not they can still go and make their applications under the Zambrano route rather than the leave to remain route. And it's important to say that when it comes to our 2.5 year route applications, under the immigration rules, they specifically require that somebody who is solely responsible or somebody who has direct access to a child or somebody who normally lives with a child can prove that they have that parental relationship with that child can make an application. And so in regards to the case of Akisenya, we all know that Miss Akisenya, who had children, had left the Zambrano route to be able to apply for 2.5 so that she will be given recourse to public funds. She then found out that it's possible to now be granted indefinite leave on the Zambrano route, which was not so before. And she therefore decided to take the case to court because the Home Office refused her application. This has obviously gone on, and the High Court has made their decision. I mean, the Court of Appeal has made their decision after the High Court decided to grant her appeal. And the Court of Appeal has also said that, of course, as a primary carer, she would not have had the chance to apply under the immigration rules because she was the sole primary carer of her children, and they would not have um, allowed her to make the application had it not been for the fact that she would be the only carer for the children. And if she left the UK, the children will obviously would not have any support whatsoever. But when it comes to those who have, should I say, exempt persons as part of the family, so you know that your child's parent who is British or who is settled here in the UK is able to look after the child if the child they said you were to leave the UK. Of course, if there's another primary carer who can care for the child, then that will make you exempt from applying under the Zambrano route. So one of my clients said to me, but why is it that they keep saying that people who are primary carers of British citizens can still apply under Zambrano? But they obviously wanted to understand what it meant by having those exempt persons, which is different to our immigration rules. So, under our immigration rules, if the spouse or the parent of the other child or the child that you have is British or settled, you will still be able to make the application because that was what was the premise for which you were making the application. But under Zambrano, you wouldn't because you are an exempt person. There's another primary carer who can look after the children. And so if you were to be removed from the country, the other primary carer would be able to take care of that child. But if you both do not have leave to remain and you are relying on that child who is British because maybe that child has reached the age of 10 and they are now making an application for registration. So, an application for registration is for the child to become British. Then it means that you can rely on that British child to have your leave to remain. And so it's important to know what the difference is. If you are unable to make your application under the immigration rules, and of course, you are required to make the application under the Zambrano route, why not? Because you do meet the requirements, and therefore, if both parents do not have leave and are relying on that child, they can go ahead even now to make an application under Appendix EU for derivative rights, and then after a 5-year period, be granted indefinite leave to remain. So that is that in terms of the Akisenya case. And so those who are on their leave to remain, please, if you haven't gone to see a solicitor, please continue on your leave to remain route. Do not assume that it is something that you can apply to if you are a primary carer and you haven't sought legal advice. So please do seek legal advice before making any sort of application under the Zambrano route.
Okay.
So, yes, I will
Right.
leave it there.
Yes, right. You know, when you were talking about the Ukraine issue, I wanted to ask you a question, but I didn't want to interrupt you.
Oh, sorry.
You know, those who are trying to regularize their stay in the UK, there might be some of them who are, you know, in the detention center waiting to be deported back to their country. Such people, is there any way the government, you know, or the Home Office can overlook, you know, their application and make a decision, you know, reversing their decision to deport them? The second question is, I know we have a lot of Ghanaian students in Ukraine. I know BWF solicitors have a branch in Ghana. It's just a question. Is there any information that might have been passed on from the, you know, the government measures to try and get our students back, or any way they could be, you know, kept in a safe place?
Okay, so in regards to the first question, if, for instance, there was a Ukrainian here who is being detained, and of course, has to be sent back to Ukraine, I think that it will be up to that person's legal representative to put in further representations for them not to be taken back to Ukraine because of what is currently going on. And you will have to, of course, use every thing at your disposal. So if, for instance, in Kiev, where a lot of the Russians are now infiltrating, if you are able to say that, well, my place of residence is not too far from Kiev, and there's no way I would survive if I were to go back there, as the war is very heavy-handed in that particular area. And it's almost as if you are throwing me into the dark for me to go and die. And as part of our human rights, I know that you have the right to be free from torture and inhumane treatment. And so we, should I say, are adhering to that as a government and as a people. And so that is something that I would say your legal representation should also make those representations to the Home Office so that they know that this is what your current situation is, and therefore they shouldn't remove you just as yet. And most bail applications will be granted in that regard, unless they have decided to put you on a flight. And if that is the case, if they've already booked a flight for you to go on, then it would mean that your legal representatives will have to apply for an injunction with the tribunal, and that is how that will be stopped. But in any case, if representations are made, I'm sure a bill can be given. And then in regards to your second question, you were asking about Ghanaians who are in Ghana as well. And I'm sure that most students, I'll put it that way, will now be making attempts to leave the Ukraine. I'm not sure how many students who are Ghanaian in the Ukraine. There might be a number of them, but I haven't heard about the Ghanaian government making some efforts to remove Ghanaian students from the Ukraine. And so I think that it will be up to individual students to make every effort to leave the country as soon as possible. And I know that they would have had some news of this coming in the past week or so. So a lot of them would have made some sort of efforts to leave. If not necessarily going back to Ghana, they may obviously try and move to nearby countries around, around them as well. If we do hear about the Ghanaian government putting in place something for them, I will announce that as well.
Okay. Thank you, Laura Eunice. So, ladies and gentlemen, if you just joined us, this is our Saturday Legal Show, hanging out with BW Solicitors, with your host, Vicky Newton, and my guest, Mrs. Lawyer Eunice Achampong. She is a seasoned solicitor and also a partner at BWF Solicitors, one of the best solicitor firm in the UK. They specialize in immigration and nationality, Ghana law and practice, family law, dispute resolution. So if you have any issues regarding what I've mentioned, look further at solicitors on 0284 937340. Lawyer Eunice will give us all the details and the address to their office at the end of the program. If you'd like to contribute to this program, yes, we'd like to hear from you. You can do so on all our social media handles, especially Facebook and YouTube, at BWF Solicitors. Lawyer Eunice will be able to answer your questions. Remember, this is a free consultation. So just jump on this opportunity and send in your questions. Please share to all your contacts and loved ones. And I believe this legal education program will benefit them. If you prefer to call us live in the studio, of course you can do so on 0744 861 9711. The number again, 0744 861 9711. I would love to hear from you. You can also send me a WhatsApp message as well. Today's topic is, does receiving some type of disability benefit exempt an applicant from the 18,600 financial requirement? Lawyer Eunice is going to delve into it, answer a few questions, and I believe at the end of the program you get a better understanding of the requirements. Lawyer Eunice?
Hello.
Yes. So, who under the immigration rule is exempt from meeting the 18,600 requirement?
So when we look specifically at Appendix FM of our immigration rules, which has to do with family members making an application, today I decided to specifically look at those that are partners. And so usually when you look at the requirements for partners,
Okay.
it says that as part of the financial requirement, they are to have an income of at least 18,600 per annum. And if they don't have that income of 18,600 per annum, then they would usually need to show that they have savings of about 16,000. And in addition to that 16,000, if there's any shortfall in the savings, then it has to be multiplied by the 2.5 years that they will grant to the applicant who will be entering, or the applicant who is here in the UK. And that is a lot of money. It's over £30,000. So I think that because there is a lot of money involved, it makes sense for applicants who are not able to meet the requirement to obviously give themselves some time to have that amount increase, either that they do more hours or they sometimes have to do two different jobs to be able to make up for that amount of money. But in cases where a partner is disabled and the partner, of course, is receiving some form of disability allowance, whether it's disability living allowance or severe disability living allowance or some form of independence, personal payments, or usually you have those who are in the army who have left or been discharged from the army, and because of some form of injury that they've had, they are also receiving some armed forces payments as well. So there are some areas, or should I say, some forms of disability benefits or allowances that will be given to a person that obviously can show that they have some form of physical disability. And I know that formerly the disability living allowance that we used to call it is now called personal independence payments. So in terms of those as well, if you are receiving that, then you don't necessarily have to meet that 18,600 requirement. What they say is that you should be able to meet a maintenance requirement, which would not have to include you showing that your income for the year is the 18,600 that they are looking to see. So it's a good thing that at least they consider that those that are physically disabled in a way and are receiving such benefits can exempt themselves from paying a fee like this. And of course, if you're a carer and you are receiving carers allowance as well, you also come under that bracket. So yes.
Okay. Okay. All right. So, Laura Eunice, what is the maintenance requirement then?
So in terms of meeting the maintenance, when we look at the Home Office guidance on what it is to meet a maintenance requirement, they look at case law as well. And you have cases like KO or Volvo, which talks about the maintenance being, should I say, equal to the income support rate once you've taken your net income. You know that you're going to pay rent, and you know that council tax is also another thing that will come out of your expenses. So once you take your net income, you take away your rent, and then you take away your council tax, whatever is left, they assume or they want it to be as a person who will be receiving income support here in the UK. So usually you would have somebody receiving income support on a weekly basis. And so they want to know that the income that you're receiving, whether it's from employment because you are working for someone, or whether it's self employed, so you may have your own business and be working for yourself, or whether it is your savings that you have, or some form of income that you are receiving every month, because there are some people who invest, and so they receive some form of income every month from their investment, or every week from their investment. So all of that counts towards your income. The only thing that will not count towards your income will be like third parties giving you money. So if, for instance, I'm your mom and I'm giving you money, no, that will not count towards your income because it's not going to be regular. So they want your regular income. So, of course, if you are able to show that your income, if you take away your um, rent or your council tax, whatever is left behind will be
Yeah.
equal to that income support rate. That is what they call a maintenance requirement. So you don't necessarily have to show that you are earning this amount every month, but you
Mm.
are showing that every week. For instance, if I were to look at an income support rate for a parent and a child, the child they usually give is about £66 um 80. So that amount will go to that child every week. And then for the parent, who's a single parent, they will get about £74 40 for that week. And so you want to make sure that your income will give you that amount of money every week. So depending on the number of children you have, or whether it's a joint parents family, then you have to see whether the income will be sufficient. But that is essentially what the maintenance is about. Yeah. So that
Okay.
you know that you can look after yourself every week, you can feed yourself. Yeah.
Okay. All right. Laura Eunice, can a person relying on the COVID concessions in, if their income dropped?
Okay. So in terms of people who may have had to, should I say, lose their income as they would normally receive it. So there are those that had to be put on the um, government retention scheme, where obviously their pay was reduced to the 80%. And there are those that are self employed that had to also receive the government self employed retention benefits as well. So, depending on the time in which the income dropped, because
Mm.
the government scheme ended in October 2021. So, if your income dropped after that period, which is October 2021, um, if you are able to still show that you will meet the maintenance requirement, then that's
Mhm.
fine. But if your income has dropped so low after the October 2021 period, where the government had told people that they were no longer going to keep the scheme going, then it means that you will have to wait until such time when you are receiving enough to meet that maintenance requirement or that income support rate that they are expecting that you should meet. But if your income dropped just between the COVID pandemic time, which was from March 2020 to October 2021, then of
Oh,
course you can rely on that. But I think that they're when it comes to maintenance, they look at the now. So I'm hoping that anybody who is seeking to rely on their income now will be able to show that it does meet that income support rate.
okay. But Lawyer Eunice, how about someone who does probably lost his or her job
Mm,
during the pandemic, but at the moment working with agencies? They might be working 5 days a week, but just that they don't have a contract in place. What do
mm.
they to prove?
So such a person, of course, when it comes to the work that they are doing, there are some agencies that will give you a contract, and there are some agencies that would tell you no. So it means that you'll be working on a self-employed basis. And if that is the case, it will mean that you will have to then show that you are filing your income. But as we all know, when it comes to self-assessment, you have to have 1 whole years of assessment before they can
Exactly. Yeah. Mhm.
assess your income. But the thing I love about our maintenance requirement is that at
Mm.
least if you have pay slips and you can show that, of course, this is how much I am getting. I am not employed, but maybe I'm doing agency work. This is how much I'm getting every month. And this is what I get per week. And I know that even with this amount that I am getting every week, I am able to feed my children, I'm able to feed my husband and the rest of it. So if that is what you have, then you can show and say that this is how much I'm receiving. It goes past the maintenance requirement that you are looking for,
Looking
and
for,
therefore
yeah.
I am obviously relying on this to be able to make my application. Yeah. So
Oh,
if somebody is in that situation where they have 0 hour contracts or they are working with an agency, they can
mhm.
still use their pay slips and bank statements which show that this is their net income. Take away their rent, take away the council tax, they still will go over and above maybe the income support rate for a family where the husband and the wife are living together with the children, and they
Right.
want the home office caseworker to consider their
Oh,
income in that way.
okay. All right. Okay. Ladies and gentlemen, this is Hanging Out with BWF Solicitors with your host, Vicky Newton, and my guest is lawyer Eunice Champong, a partner and also solicitor at BWF Solicitors, your number one immigration law firm here in the UK. They've also got a branch in Ghana. If you'd like to contribute to this program, you can do so on all our social media handles, especially Facebook and YouTube. Today's topic is: does receiving some type of disability benefit exempt an applicant from the 18,600 financial requirement? If you prefer to call me live in the studio, the number is 0744 And yeah, I'll be very happy to hear from you. Eunice is here to answer all your questions. Laura Eunice, I've got Nana. Nana says, "Good afternoon, Vicky and Eunice. I'm really enjoying your program. I'm physically disabled and receiving personal independence payments. I'm unable to work and would like to bring my partner from Africa to support me. Can I make the application for him?"
Okay, so with Nana, of course, if you are receiving personal independent payments, and you're not working, they would like to see if you meet the maintenance requirement, like I said. So in such a case, if the personal independent payments that she's receiving, if you consider whether that in itself will meet the income support rate, then that's fine, because they do consider public funds as well. Um, I'm not sure if she's receiving other benefits as well. So maybe she's receiving universal credits, because I'm not sure how she's surviving without working. So it might be that she is also receiving universal credits to help with her housing cost and to help with other things as well. If she can show that her personal independent payments and maybe any other benefits that she's receiving will meet that income support rate that she is meant to show, then of course she can rely on that. Personal independent payments, they're not necessarily huge amounts of money. They are they're very little. So it might be difficult to show that she can meet that income support rate. Um, Sometimes it's good to have a part-time job just to do something for a few hours each day, just to help support the growth, because I know that um, there are some jobs that are very um, flexible and how do I put it, disabled friendly, for want of a better word. So there are certain jobs that you can apply to even if you have a physical disability. So it's not all grey. I know a friend who was formerly at my university, and she was almost blind because she used to walk around with her stick. So the last I heard, she was working for the Home Office, and I said, "Wow, that's amazing." So yeah, so you can have very, should I say, disabled friendly jobs, and you don't necessarily have to say because of a certain disability, there wouldn't be any employers who would take you on. So maybe she might have to do something small to support that, because from what I know, they are not the personal independent payments are not that much that you can say that you are relying on that as a person to then bring somebody else. Yes, so she might have to look into other means by which she can increase her income so that it will meet the income support rate that they're expecting. Yeah.
Okay. I've got Kofi K's question here. It said, I was listening to the program and wanted to find out if I can be put on the 5-year partner route if my wife is receiving severe disability living allowance and I am working. I'm currently on a 2.5 years on the partner route, which is due to expire soon.
Yes, so you can be put on the 5-year route as long as you can show that you are meeting that maintenance requirement. So the whole point is to show that you're meeting the requirements. So they say that if you can't meet the um, 18,600 requirement or the savings that I mentioned at the beginning, but you can show that your spouse or one of you is receiving any of the benefits I mentioned, whether it's the personal independent payments, disability allowance, carers allowance, even those things will allow for that person to be exempt from that requirement of the 18,600. So if you are saying that your partner or you yourself is receiving such benefits, or should I say allowance, then you can say that, of course, you have met that requirement under our immigration rules, and you can show clearly that if your rent and your council tax is taken away, you will still have enough money to look after yourselves, which is equal to that income support rate that they give to family members here in the UK. So it's good that he's working. Hopefully his income can show that they meet their maintenance requirements. So if he does show that, then he can be put on the 5-year route to settlement instead of that 10-year route to settlement. So yes, it is possible.
Right. He asked one question. He's saying, I started working about 3 months ago. Would I be able to rely on the pay I receive?
So if he started working 3 months ago, even better. It's not as in our specified requirements. So I know that if you are showing that you meet that 18,600 per annum, one of the things which you will be required to show is things like your pay slips. So you have to show at least 6 months pay slips, at least 6 months bank statements, and a letter from your employer to show that you are employed by them. And then this is optional. You can include your P60 and any HMRC tax returns for those who are employed. Obviously, for those that are self-employed, you have the whole self-assessment to be done, and you have to have it done for the previous year, and you have to show that you have paid your tax in regards to that. And obviously, you have to show some form of invoice to show what kind of work you do when you say you're self-employed. So considering that he's saying he's worked for the past 3 months, I hope it is employed work and not self-employed, then it would mean that he can show through his payslips that he is receiving a certain type of income. And if his income is something that we say is the net income, so we take away your gross, which is the national insurance contributions and the income tax that the HMRC take when you are giving your total pay, whatever is left is your net. And so if your net income is able to meet that maintenance requirement, then that's fine. You don't have to worry so much. The only issue will be when you are self-employed and you have only just started. So that will be, I think, the only downside in such a scenario. Yeah.
Okay. All right. Okay. I think we will go for just a short break with an advert from Bw Solicitors. And when we come back, Lawyer Eunice will give us her details for anybody who would like to contact her for help and, direction on his or her application. Don't go anywhere. Stay tuned. We'll be right back.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bw has over 29 years' experience as a lawyer in the UK. BWF Solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Welcome back. Laura Eunice, if you could please give us a brief of what we discussed so far, and for the benefit of those who would like to contact you, would like to have your details, address, for them to get in touch with you.
Okay. So yes, we've been discussing about those that are exempt from meeting that 18,600 threshold for partner applications. So if for one reason or the other you are receiving, let's say, a disability living allowance or personal independence payment, or even a carer's allowance or independent support payments, or those in the armed forces who have been discharged because of a disability will also receive the armed forces benefits as well. If you are receiving any kind of benefits in such form and you are saying to the UK government, I am receiving such benefits and therefore I am not able to meet that 18,600 threshold, but I will be able to maintain myself, my husband, and my children if that's the case. And therefore, this is my income, and I would want to show that I meet all the other requirements, whatever they may be, to be able to make this application. So yes, it is not applicable to most people, but to the people that it is applicable to, there is that benefit of making such an application. And at least if you can show that you are able to maintain yourselves, then if there is the application made for whether it's entry clearance or leave to remain or even indefinite leave to remain, you will surely be granted that route or that leave for that particular application that you are making. So yes, as always, we want to make people understand that we do not just deal with immigration, but we do have areas of law such as family and civil litigation where we also practice. So if you do want to contact us, you can do so by phoning us on 0208 493 7340. And our offices are opened from Monday to Friday from 9:30 a.m. to 6 p.m. We usually take bookings, and so our consultations can either be physical or you will be told you can have remote bookings done where you can have it either by phone or via Zoom. And so if you do want to have face-to-face consultations or Zoom or phone consultations, do phone the office and they will book you in. My personal number is 075 3581 3910. So 075 3581 3910. So if you do want to phone us, then let us know.
Eunice, please. I've been bombarded with some few questions on YouTube. Do you
Okay.
mind if I quickly read the question?
Okay.
Don't mind, yeah. This is from Jacob Stephen. Can a family unit go in at once on 7-year rule application, or is it possible? Reason is few families I know has done it successfully, but information from someone else says it is not possible.
Okay, so
You
I
say,
understand the question he's putting. So usually, if a child turns 7, we usually say that it is possible for the parents to rely on that child to be able to have their leave granted to them for 2.5 years.
"Mm,
With regards to a child who both parents maybe do not have leave to remain in the
yeah,
UK. So sorry, let's say that the child has turned 7 and both parents are now seeking to rely on this child. All three of them are making the application. It's not just the parents, it's the
right,
child and the parents. And a child who is 7 will be making the application based on their private life. So
yeah,
they are making the application to say that under our immigration rules, I am allowed to make an application under paragraph 276 AD to show that I have private life here in the UK. So if I can
okay,
show I've lived in the UK for a continuous period of 7 years, I've formed roots here in the UK as a child. I I have all my social ties here. My culture is here in the UK. The UK is my permanent home. I've never
okay,
been anywhere outside of the UK before. And indeed, everything that this child does, whether it's at school or the extracurricular activities outside school, all show that this child has indeed formed deep roots here in the UK. Then, of course, you include that evidence in addition to the parents' evidence to show that they have a genuine parental relationship with this child.
okay.
And
Mm.
so it is possible to have the family make the application together. I would even advise for them to do it separately.
Oh, because he was even thinking of, I think he said he wanted to do the 7 year for the child, then the rest of the family will come later or something.
No,
Right. He's asking if the application will go on the FLR or HRO.
it's definitely the FLRFP.
Okay. Okay. All right. I think if you don't mind, just one last question
Yeah,
because they are pleading with me. Vicky, please ask Lawyer Eunice this question for me. 1 minute. Just scroll through quickly.
that's
All
okay.
right. Yes. I've got Mami Kriya also asking if um civil partnership can be changed to marriage after some time, or what is the process on civil partnership?
Okay, so usually when we say civil partnership, it's referring to those that are either homosexual or gay. So somebody who is gay will not be going through a normal marriage like we would
Okay.
if we are heterosexual. So the civil partnership is to do with those that are either gay or homosexual.
So,
And
Laura
then
Eunice, it can't be between a boyfriend girlfriend.
no, no, no. So in the immigration rules,
Oh,
civil partnership is basically referring to
okay.
a single sex relationship.
Single sex relationship. Okay.
Yes, yes.
Okay. I think that's it. If you can please go back and give us your contact details again, please,
Okay,
Laura. Yeah.
okay, that's fine. So as I was saying before, if you do want to contact us to book an appointment, either remotely or via face to face, you can give us a call on 0208 493 7340. So it's 0208 493 7340. Thank you so much, Vicky.
On that note, Lawyer Eunice, we always come your way every Saturday, 1 p.m. to UK time. We will come your way next week, same time again with another interesting topic. If you want to contact Lawyer Eunice, she's already given us your details. Now, for the benefit of those who couldn't join us from the beginning, probably missed most parts of this show, you can go back and watch the replay on our YouTube and Facebook pages at BWF Solicitors. You'll be able to watch from the beginning to the end. And if you have any queries or you need support with your application, Lawyer Eunice and her team are available to support you. So that's it. Thank you so much for staying with us through the program. My appreciation goes to all of you. Without you, I mean, there is no show. We are so happy and excited, with the support we've been receiving. It's making our show go far and wide. One of the successful shows you can find, on all our social media handles, focusing on immigration and law. Tune in again next week. And Lawyer Eunice, if you have anything to say until then probably have a lovely weekend, and we'll see you next week.
Definitely. So please have an enjoyable weekend, and then next week we'll see ourselves in a new month.
Yes. And we also want to, say that, what is going on with Ukraine and Russia. Yeah. We are always praying for Ukraine. I will endeavor each and every one of you to intercede on their behalf, those who are stranded. Our heart goes out to all of them. So we'll continue to pray for them, and we pray that this will not, be prolonged. It's going to end very soon. So our hearts once again goes out to all the people who are stranded in Ukraine. Yeah. So take care of yourself, and God bless. Bye-bye.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF Solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.